Hi, I'm Top Orlando Realtor Scott Garrison with my partner Diana Sacoto, and we're here with Lance Ragland, who's an attorney, specializes in estates, probates, trusts here in Winter Springs. Look him up on Google and you'll see he's one of the top rated attorneys here in the area if you're looking for an estate, probate, or trust.
Lance, besides of being a great attorney, he also does great things for the community. Like he's a co-founder of and currently serves as a member of the board of directors of Help Kids Play Sports, a non-profit organization dedicated to provide funding for disadvantaged kids to participate in local sport leagues. And also he's a part of the Oviedo Rotary Club that I'm proud of be part of too. And he serves as a member of the board of directors, and he's a chair of the service projects committee.
So Lance, tell us a little bit about what is it, how would you describe what it is that you do?
So for the most part, we try to help people make sure that when they have left this earth, that their assets are going to be distributed in a way that they desire to have them distributed to the people that they want them to go to. And most of what we do allows them to direct who's going to be in charge of making sure that that happens in the way that they've directed in their documents. So we do wills and we do trusts and other documents that help with that sort of thing as well, so that the wishes can be carried out in the way that they want them to.
Most of the people think that having a will is enough to protect their assets and to do their wishes.
Yeah, so the will does allow you to direct who would be in charge of making the distributions that you can also direct in your will. So in your will, you are able to direct to whom these assets are to go and how you want them to be distributed. And you can also choose the person that you are most comfortable with handling those distributions for you once you are gone.
Are wills the best way to do this?
They're not the best way. They are a tool that we use. We like to use revocable living trusts. The trust can help avoid that probate process. It can also provide some other advantages, such as asset protection for the beneficiaries that you're leaving the assets to, depending on the circumstances. It also allows you to provide for what is going to happen to these assets if the initial beneficiaries that you've appointed or nominated aren't alive at the time that you pass away. And so we can get very complicated as necessary through the trust to make sure that no matter what the circumstances are at the time that you pass away, that you've got things set up the way that you want them to be, and you're in control of that and in charge of that, versus not having a plan at all, in which case the probate process will actually direct where your assets are going to be distributed, which might not be the way you want them to be distributed, and it will also help determine who is going to be in charge of making those distributions, which also might not be who you want to be in charge of that. Actually, the trust is a better option. It provides more benefits, but sometimes a will can be enough. It just depends on the circumstances.
Yeah, if all the circumstances are perfect, the will is enough.
Correct.
But you know, life is not perfect.
That is exactly right. And you know, every family is not the same, and you know, blended families and things like that, they bring about certain aspects that Florida law may not provide for in determining where the assets are going to go. If you don't have a will, at least a will or a trust that's going to direct all of that for you.
So, yeah. You've been an attorney for quite a while. Everyone loves an origin story. How did you end up here in your great office? How did you get into this?
So I had a mentor when I was really young, actually. A family friend kind of took an interest in me, and offered to sort of assist me. He was a lawyer, local lawyer here in town, actually became a local judge here in town. And as a young person, I mean, even as young as 13, 14 years old, he kind of, offered his assistance and direction to me. And I really thought he was a neat guy and respected him a lot, and in a lot of ways wanted to be like him. And it just, once he expressed that interest in me, it just took off from there.
Oh,
and I really didn't veer from the path all that much since I was 13, 14, 15 years old.
Oh,
What an impact we can have on young people.
Unbelievable.
Just with a small amount.
Unbelievable.
So from the time you were 13, 14, from the time you were a little boy, you said, I kind of want to do this.
I kind of want to do this.
And here it is, we're kind of on the opposite, you and I being a little boy, and, and you're still doing it, right?
Absolutely.
So how did you go from that inspiration, just kind of roughly just take us through like the inspiration to become an attorney?
Yeah.
And how did you end up here? You're a sole proprietor, sole in your practice.
Correct. Yep.
Okay, good.
Yep. So when I decided that the law was going to be my thing, I really thought that I was going to be a litigator of some sort. I'd be in the courtroom every day. And then I got to law school and realized pretty quickly that that wasn't what I was interested in doing. So I was a little nervous at that point because I wasn't sure what the options were, but then I kind of stumbled upon the wills, trusts, and estates practice area, and then just kind of followed through with that. And I got out of school and worked for a couple of different law firms doing estate planning stuff, and eventually opened up my own office in Altamont and brought on a partner, and that lasted for a couple of years, and I got a really good offer from a really good law firm in town that I really couldn't pass up. So I closed that law firm down, and I thought I'd work with that law firm for a few years and kind of learn what they know and go out on my own. Well, 12 years later, I was still sitting there and thinking, maybe you kind of need to make a decision. Are we going to stay at this law firm, or are we going to do what we thought we were going to do at, when we started here 12 years ago? And so I just decided to move out on my own. It's been about 10 years now that I've been out on my own, and I had an office over in Oviedo for a few years, and we moved over here about 3 years ago, and it's been great.
So when you're looking for an attorney, it's important to get someone who has the passion to do this. And obviously he has the passion to do this since he's been a little boy. This has been the only thing you've known, right?
Really? Yeah.
And you know that you've got the right attorney when you're not dealing with some big impersonal corporate monolith. And that's probably, I'm guessing, the reason why you wanted to go out on your own.
Absolutely. Absolutely. The firm that I worked for was an absolutely wonderful firm. The education that I got there was just priceless, invaluable. But I really wanted to take what I'd learned there and sort of do my own thing, right? And be my own boss. And it's worked out great.
So if you look online at Lance's reviews, you're going to find the same thing. Most people don't want to deal with some huge office building with 16 layers of receptionists and people between you and the attorney. You want to get an attorney who's going to sit down with you at a table just like this, look at you and help you, and that's what you do. It's one guy,
Absolutely.
One receptionist, one office, tremendous amount of business, but it's the personal touch that's going to make the difference in most things, including making sure that your will, your trust, the probate, it all gets done right.
That is correct.
And when you're looking for someone also here in East Orlando, it's important to get someone with ties to the community. It's the difference between going to a local coffee shop and shopping at Starbucks, which is definitely not part of the local community. And you've been part of the community for a long time. What high school did you go to?
Long time. I went to Lake Howell High School, which is just down the street,
Like
maybe
10
a
minutes away.
mile and a half from here, maybe. I actually went to Tuscaloosa Middle School, and in 5th grade I went to Sterling Park Elementary.
Oh my gosh.
Since 5th grade, I've kind of been living in this community other than going to college and going to law school.
Well, even in college you went to Gainesville for a while, but you also went locally here, correct?
At UCF, yep, absolutely. Kind of back and forth a little bit between UCF and Gainesville, and then law school at Stetson in St. Petersburg, and I worked in Tampa, St. Pete area for maybe 2 years after I graduated, and then realized it was time to get back home, and so I've been here ever since.
For sure. So even when you went to law school, if you were to Google the closest law school to East Orlando, that's probably where you went, right?
Yeah, it is probably one of them. I think when I started there, Barry Law School was not accredited, and so it wasn't really an option that I was considering at the time, although obviously it has been accredited since, and now there's FAMU and certain other law schools that may be a little bit closer, but Stetson may have been the closest at the time.
Stetson is like 30 minutes, 40 minutes away right into land, right?
Well,
so even that's local.
Actually, the law school is in St. Petersburg, so it's still a couple hours away, but you know, there's not a lot of law schools in between here and there, at least 27 years ago whenever I was going to law school. So
not only did you go to elementary school, to middle school, to high school, to college, went pretty close here in law school, you spent your whole life here in the community as well. Now you're part of the Rotary Club. Tell us a little bit about what you do for that.
Oh, the Rotary Club. That Rotary Club is it's an absolutely wonderful organization that I've been a part of ever since I moved my office from Winter Park, or I left the old office in Winter Park and opened up my office at Oviedo. You know, it's just like everything else. You know, you join these organizations hoping that it may be good for your business and networking and things like that. But very quickly with the Rotary Club, you realize that you're in this club with a bunch of wonderful people who care about the community, and it can't help but rub off on you. And the main focus now is just to be involved in that community. I am the chairman of the Service Projects Committee for the Rotary Club, which is a big sort of aspect of what we do, which is to kind of go around, identify needs in the community, and help people with certain things. It may be a yard cleanup for somebody who can't get out and do it on their own. We've painted houses before, we've cleaned up the inside of houses. We just helped a lady box up a bunch of stuff for a move that she was embarking on and didn't have any help for. So we do a lot of stuff.
You deliver meals
on wheels, absolutely. Yep.
So how many attorneys you know are out in the middle of the afternoon delivering Meals on Meals to local people?
Yeah.
So the purpose of the Rotary is to give back on the local community level, back to the community.
Yeah, you have to have a desire to help. Because if you're not there to help, you're probably not going to be there for very long.
So when you're thinking about hiring an attorney, you say, who should we call? You want to get someone who's good. You want to get someone who has great reviews. You want to get someone who's accessible like this, so you can kind of see before you get a chance to come in and meet. It's also important to get someone who's involved in the local community, and having gone to elementary school here, within a couple of minutes of your office is about as local as you get. How long have you been practicing law?
I took the bar exam and was admitted to the bar 27 years ago.
So that's some serious experience. You were not figuring out how to do this.
That's right.
Good.
That's right.
What would you say that you're best at professionally? What's your thing that you say, this is the thing that I can do?
Well, I really enjoy meeting with people, and my philosophy of doing this, and I've encountered lots of different philosophies throughout my career, but my philosophy in doing this is explaining all of the options, the issues that may come up with all of the options, and really trying to give an education to my clients, my potential clients, in a way that they can understand what it is that we're talking about, right? And then allowing them to make an educated decision based on what we've talked about as to what the best plan is for them. Now, obviously, I'm going to make a recommendation in most cases, but in the end, I want the client to kind of understand what the issues are, and I want that client to be comfortable with what it is they're going to end up doing with me, if anything at all.
Who would you say your typical client is? Who are the people who should be thinking about hiring you?
It's just about everybody, but sort of the The bread and butter of my practice are just normal, regular families. It's interesting that we've got a lot of younger folks these days that are concerned about these issues for their children, and it's not just the elderly that come in every day, but there's just a huge a huge range of folks that come in that are interested in at least talking about this type of planning these days. And it's great that that kind of information is out there, especially for young people who have children and historically may have never considered what needs to be done when you have a child and you're starting to accumulate some assets and things like that. So it really is a pretty large range of people.
But it's not just the assets, because when I just have my child that he's 17 now, someone told me, it's like, do you have a will? I say, no, because, we just have a home, we don't have much. So if something happens, it's going to go automatically to the child. And they say no, because the child becomes part of the estate. So the estate is the one that is going to decide who is going to the child stay with, live with. And in our case, that we didn't have any family.
And especially, when you're talking about younger couples with younger children, and by younger, that can be, even 25 or 30, to be honest with you. You may not want your children at a particular age to be the beneficiary of your assets and receive all those assets at a particular age when maybe they're not really equipped to make good decisions with those assets. And so a good estate plan will allow you to maybe put somebody else in charge of managing these assets for the benefit of these children until they reach an age where you might be a little bit more comfortable with them having control and access and things like that. And literally, if they're under the age of 18, you may end up, or after you're gone, your children may end up in a guardianship situation where the court has to get involved in appointing somebody that you may not want to be in charge of managing those assets for the benefit of your kids. And it's costly and it's time consuming and it's something that you'd want to avoid. And a good estate plan is going to do that for people. And it's important that the younger folks understand that those are issues that can come up. So it's not just for the elderly, that's for sure. And
then one extra thing, so as most of you know, I have a special need child. And Lance helped me with the special need trust, because that's super important. If you have a special need child or person around you, it's a key. He explained me everything, and I did that, and I feel in peace.
Yes, it's I mean, those are obviously some special circumstances that may precipitate you wanting to come in and at least discuss those things, and we've got some tools that we can use to make sure that those things are being taken care of in the way that you want them to, without eliminating the child's ability to receive whatever other government benefits that they might be entitled to receive, and also making sure that you've chosen the person that you would want to be in charge of managing those assets for his or her benefit in those types of situations. So it's not just young people, it can be special needs people. There's just all kinds of folks that may need that kind of guidance, at least for a period of time in their lives, and a good estate plan can provide for that.
So I have people that they say they have a ladybird deed. So what's your opinion about that?
A ladybird deed is a deed where you can actually, in essence, name a beneficiary on the deed to receive the property whenever you pass away. and it's automatic, and it avoids the probate process. So the idea of it is a really good idea. In most cases, it's something that you would use if you don't have a trust, right? So you might put a will together, and then if you've got a homestead property or other properties, as a matter of fact, you can transfer those properties to your beneficiaries without probate. And the idea with the ladybird deed is it's also referred to as an enhanced life estate deed, which means the enhanced part means that not only do you have this life estate in the deed, which means you have the right to live there for the rest of your life, and you haven't really given the property away until you pass away. The enhanced portion of it means that, and there's language specifically included in the ladybird deed that says that you have the power basically to do whatever you want to do with that house during your lifetime. You can change it so that different beneficiaries are going to receive it. You can sell the property. You can remortgage the property. Anything really that you want to do. There are a couple of potential pitfalls that I do know that some people have experienced. One of which is that the title companies sometimes aren't necessarily familiar with these things, although I think that's getting less and less true as we move forward. But sometimes, despite the language in the deed that says that you can do whatever you want with these assets or with that property, without the consent of the people that you're leaving it to, sometimes when you go to sell it, the title company is going to want those people to consent anyway. And if it's a situation where a child that you're leaving it to doesn't want you to sell the house, it's possible that they could block the sale of your house. And so when people hear that, a lot of times they sort of back away from the ladybird deed because they want to be in control of what's going on, and they don't want their children or anybody else to be able to tell them what they can do and what they can't do with the property. Another potential issue is that sometimes, and this is particularly true with tax liens, but if the person or beneficiary that you're leaving this property to, whether it's a child or a grandchild or a friend or whomever, if they end up with creditor issues, it's possible that a lien can be put on the property because their name is on the deed. And whether that's right or wrong, you may have to spend some money to defend the fact that, you know, that's not the case. And if you try to sell your property and they want you to pay off the lien, it may cost you, first of all, you may end up having to pay the lien, if it's a tax lien, certainly. And if it's some other type of lien, you may have to spend money to get that removed and get the consent of those creditors to move forward with the sale, which makes things pretty difficult in a time when you just want things to go smoothly with the sale of your house. And so it can present some challenges, but in the right circumstances, it's a great tool that can be used. It's but it's just that, it's a tool. It's not a comprehensive solution to an estate plan like a trust would be. And I think I said before, if you have a trust plan, you probably wouldn't do a ladybird deed. Instead, you would actually transfer the real estate to your trust, and then the trust would have all of those provisions that would govern what would happen, for instance, if your beneficiary passed away. Right? You could be in the same situation where, you know, we talked about before with like beneficiary designations and things like that. If you leave your house through a ladybird deed to a person who, God forbid, passes away in a car accident with you, now what happens to that property? It's going to end up going through probate, probably. And it may end up going, let's say, to the child of the child that passed away in the car accident with you, and that child may be 10 years old, and now you've got a guardianship. So now you've done a probate and a guardianship, which would have been completely taken care of if you had a trust plan. The great thing about a ladybird deed, if the circumstances are right, is that it's much less expensive than doing a trust plan.
And in the long run, it will be very inexpensive compared to a probate or...
Absolutely. If you do a will and you make a mistake and something doesn't get a beneficiary designation on it, or God forbid your beneficiary has passed away, and you could very well end up going through a probate process, which in most cases is going to cost you a lot more than what you paid to do the trust in the first place. And then the trust is going to be that complete package that includes the trust. It includes a will that works with that trust. It includes a power of attorney, a healthcare surrogate, a living will, all those other documents that sort of make up a complete plan for an individual. And those other documents that I mentioned are super important, obviously, during the lifetime of the individual who's creating the plan, and the trust as well at that time. But the will and the trust would take effect on the death of that individual, and the trust would just continue on after the death of that individual. In most cases, we would put the real estate in the trust. We can use beneficiary designations on the accounts to name the trust as a beneficiary on the financial stuff, so that when the individual passes away, those assets end up in the trust with no probate, which means they can be distributed to the beneficiaries with no probate. And if you've got a situation where your first line of beneficiary, you've lost somebody there, somebody's passed away, you will be able to control exactly what happens to the assets of that deceased individual, a child for instance, when those assets may be passed down to the children of this child that have passed away. And there won't be a guardianship and there won't be a probate as long as the provisions have been included to provide for all of that.
And how long a probate can take?
So a probate, the downsides to the probate are that they can be very time consuming. As we discussed, they can be extremely expensive, and they can take quite a little while to get done. A standard probate without any hiccups or issues, probably in the neighborhood of 6 months to a year to get it taken care of. And a lot of that depends on how busy the lawyer is, how busy the judges are, how busy the clerks are. So it largely depends on the county that you're filing that probate in. But we definitely tell people that you can expect it to be 6 months to a year.
And with real estate, one of the things people don't think about is when it goes through probate and you've got one or multiple properties, during that time, no one owns the property legally.
Technically.
Someone has to pay the mortgage, the taxes, the upkeep. And so there's a 6 to 12 month period where someone is responsible for the house, otherwise bad things happen, and yet they don't know that the probate's actually going to even go through to their name. And that's one of the biggest upsets we see as realtors, is someone says, okay, someone has passed on, unfortunately, and I'm like, well, I just got to maintain the house at your cost for the next 12 months, and hopefully maybe sort of it'll work out. And that's a big issue. As well, if they had a trust, it would be much less time.
Much less time, yes. And what you're speaking about specifically is homestead property, which is your primary residence, and that is treated a little bit differently than, say, a rental property or a vacation home. But you're 100% correct. There are all kinds of waiting periods and deadlines and all of that sort of stuff, but oftentimes it's a hurry up and wait situation, and you're looking at about 6 months at least before you can sell that homestead property, unless you want to go about filing a special petition with the court for permission to sell it before what we call the claims period has run, and you've gotten the homestead order on the property. So yeah, it can take some time.
And in my experience, 6 months is 12 months.
I know someone that she just finished, and it was 10 years.
Oh, well, or 10 years, I guess.
Sometimes problems can arise. There's no doubt about it.
Yeah.
And probate can take a long time if that is the case.
Because they don't agree.
Exactly. Yep. If there's conflict, there's just no predicting how long it can take to get through the process.
So I'd like to ask a couple of questions that people are thinking when they're thinking about hiring you.
Sure.
And one of them is going to be, So how much is this? This sounds expensive. How much is this going to cost? So for your average client, about approximate, they can get a will with you, or they can go with the trust package, which has got a will, a power of attorney, a living power of attorney. So just give us an idea of about like how much should they be willing to spend roughly.
Yeah, we do have some standard fees that we try to stick to. Every situation is different, obviously, and it depends if you're a single person or a married couple, or you know, just whatever your situation. And it certainly depends on whether you're a blended family. That can be a little more expensive, but a standard will package for an individual, which would include the will, the power of attorney, the healthcare surrogate, and the living will, you're probably looking at in the neighborhood of $800 for the will and all those other documents. Now, when you're talking about a trust...
Well, first with the will, it's about $800, but if it's not standard and it's a little more complicated, what's kind of the most it could go within reason?
Well, the way we do these packages, because as you start adding on the different things that may need to be added to the will, if it's not a standard situation, we sort of try to move to the trust if it's not so basic of a situation. So there are things that we can add to the will, but as you add those things, they get more and more expensive, and then in the end, if you just pay a little bit more, you're also going to avoid the probate process if you do the trust.
So somebody's watching this and they're thinking, all right, so not a will. How much is this whole trust thing roughly going to run at?
You're looking at more like $2,500 to $3,500 these days to get the trust done, which again is the trust, a will that works with the trust that we hope we don't have to use, right? It's kind of a safety net that we put in there to make sure everything gets in the trust, but the idea is to have everything in the trust beforehand. But so it comes with that will, again, the power of attorney, the healthcare surrogate, and the living will, and you're looking at, like I said, probably in the neighborhood of $2,500 to $3,500 for that type of package. And then it's going to avoid the probate process, which...
I went to a class once and told me many times, and he said, you know, when the caca hits the fan, he says, it's a very thin stack of papers. He held it up. It makes a difference between you losing everything and it going exactly the way you want. And I found that personally several times in my life. I have a lot of clients who've gone through this. Most of them don't have the papers, and it costs them tens of thousands of dollars.
Yeah, because of probate, how much a probate can cost?
So so different lawyers do it differently, right? And so, but you could be paying, you know, $400, $450 an hour to go through this process, right? If a lawyer charges hourly. We try not to charge hourly, and there are some promulgated presumed reasonable rates that are set forth in the Florida statutes, and generally speaking, they can range from 3% for an estate that's under $1 million, right? So 3% of $1 million estate would be like $30,000. So it can be very, very expensive. As the value of the estate gets higher, the estate gets higher, the percentages go lower, right? So you might be at 3% for the first part of it, then 2.5% for another portion of it, but that can get very, very expensive. Now, a lawyer also has the ability to reduce those percentages or to just simply quote a flat fee, which is what I prefer to do. Either use those rates, quote a flat fee that I think is reasonable based on the circumstances, and give the client the opportunity to say yes or no.
But it could easily be $10,000.
Oh, very easily. Very easily.
If you're watching this and you're thinking, should I even mess with this? Well, you can do nothing and you'll end up people who you want to leave the things that you've worked for your whole life to will have nothing or very less. Or you can spend $800, $1,500, or you can spend $3,000, $3,500, or you can take the burden of all of this and to the people, your children, or the people you're trying to leave the money to, leave them a bill which has to be paid for at least $10,000. And that's just the legal fees. That's not counting maintaining your properties for the next 12 months. before you do that. So you can see by planning in advance, not only are things going to go the way you want, but you're going to save the people who you want to have your assets tens and tens of thousands of dollars and years of frustration, all for sitting down with them for an hour or two, writing a little check, which everyone needs to do anyway, right? You said pretty much everyone needs to do this.
It really needs to be done, especially if you have children. But ultimately, if you care where your assets go and you care who you want to be in charge of them, making those distributions, and you care about the cost of getting that done, you need an estate plan.
So you've worked your whole life to accumulate things, to save things, to get a property, to have assets, to have people in your life that you care about, that you want to have that when unfortunately it is time for you to go. Your whole life, years and years and years. And how long will it take for them to set up a trust and write a check for $3,500? How long is that whole process?
Yeah, so we generally do it in just a couple of meetings. We'll sit down, like I said, we'll go over everything. We'll go over all of the options that anybody wants to talk about. I'll give the prices right then and there. And then the idea is let the client make an educated decision as to what they want to go forward with, if anything, and it's a free initial consultation. If the answer is, we're going to go elsewhere, or whatever the situation is, that's 100% fine. But the first appointment is usually about an hour and a half. During that appointment, if they decide to move forward, if the client decides to move forward, I will get all of the information that I need to draft the documents. It'll take me a few weeks to get the documents drafted before you leave here that day. We'll schedule an appointment for you to come back in. We'll sit down, we'll go over it all, make any changes that need to be made, and it's done. Get it all signed up and you're done.
So in less time than most people usually spend planning a vacation, and for less money than that vacation would cost, you can come in and see Lance, who is an expert in his field, been local here since he's been a little boy, take care of all of this. And the biggest benefit is to save the people who you want to have your assets hours and hours, maybe years of financial and legal stress, and save them literally tens and tens of thousands of dollars. And then you can go on vacation.
Once that piece is taken care of, now go on vacation.
And then one extra thing is like for a special need trust, what would be the average price?
So the types of special needs trusts that we do, and there are different types of these trusts. The types of special needs trusts that we do are sort of like, they're add-ons to the trust that you're already creating.
Okay.
And so we may charge $300 to $500 to add a special needs trust for a beneficiary who would need something like that to your overall trust.
Okay.
So that's a relatively inexpensive addition that provides a lot of impact and benefit for individuals who may be qualifying for public benefits at some point in their life.
So people who are watching this, there's a lot of estate planning attorneys who just look in Google, and they're kind of wondering why they should hire you. We obviously think there's a lot of reasons, but why, when someone has a will, a trust, estate planning, why should they come in and make the call to talk with you?
I think the big reason is that this is really all the work that I do. I focus my practice exclusively on wills and trusts and estates. So we are up to speed every day on what's going on in the law and with the courts, and you know, we kind of have our finger on the pulse of what's going on in this area of law. I used to do several other types of law, but mostly as it related to estate planning, like corporate and business law. But over the last 10 or 15 years, I've focused my practice 100% exclusively on wills, trusts, and estates, and that's all I do. I try to do it in sort of a casual format, atmosphere, where people can feel comfortable, and that's kind of what we're hoping to do, is that when you come into this office, you're not nervous to meet with the lawyer, you're comfortable because I'm just a regular person, just like you. I try to give people an education about what it is that I do and what I think is appropriate for them. I like to give them the options that they're interested in. We together, as the client and myself, talk together about their specific circumstances, and I can make recommendations, and in the end I want them to feel comfortable with what they've chosen to do, if anything, and if that's nothing, I want them to feel comfortable saying thank you for the education, and we're going to move on to somebody else. Good. It's 100% fine with me.
Good.
If you know that a loved one has a terminal illness, what's the suggestion?
It really depends on the circumstances for that individual and the family. It depends on what the assets are, and it depends on whether we have sort of a warning of how long it's going to be before these plans need to be implemented, right? Before that person is actually going to pass away. In some cases, if we've got some warning and we know it's going to be soon and the circumstances are appropriate for it, we can do a lot of planning that's not very expensive through the beneficiary designations that we wouldn't normally do when, you know, the person may be alive for another 50 years and we don't know what's going to happen. But if we have kind of a heads up as to what's going to happen, depending on the assets, we can get things kind of squared away fairly inexpensively by using tools like the Ladybird deed and the beneficiary designations and things like that. Now, if it's a married couple with a relatively large estate, well, there might be some things that we need to do from an estate tax perspective, and that gives us some ability to kind of, you know, if we can understand what we think is going to happen in the near future, that can allow us to do some particular specific planning that we wouldn't otherwise be able to do if we have no idea which spouse is going to pass away first. And that all has to do with estate taxes and things like that, which really aren't a concern for most people these days. For a married couple, the estate tax exemption amount right now is approximately $27 million. So we're not worried about estate taxes unless we're talking about a very, very large estate. But if we're talking about something like that, knowing that somebody is not long for this world can present some planning opportunities that we wouldn't otherwise have. And those can be more expensive. You know, that's going to involve some trust planning and some moving of assets around and things like that. But, you know, so there's different options under different circumstances. I'm Lance Ragland. I am a local wills, trust, and estates attorney. If you need help with any type of planning, to make sure that your assets are going to get to where you want them to go when you're gone, or if you've had a loved one who's passed away and you need probate administration or trust administration help, I want you to call me and let me help.